Hello there, Wanderer. Whether you're currently getting sued or preparing for the future, this guide will surely be important to you. Before we even begin talking about anything, we need to clarify the type of lawsuit you're facing, civil or criminal. Civil lawsuits are the less complicated one. They often involve one party suing another, usually for the money. They don't involve any serious crimes and can be brought by any individual or business. Most civil cases are also settled before they even make it to court, through negotiations. For example, one business not holding up to their contract with another is grounds for a civil suit to compensate for whatever was lost. The party suing is known as the plaintiff, and the burden of proof they have to meet is lower, as its standard is known as the balance of probabilities, meaning that their claim should be more possible than not. Think of it as a 51% and 49%. 51% being that their claim is possible. And for those who are unaware, the burden of proof is the legal obligation for a party to prove something. Common examples of cases are contracts, debt, personal injuries, defamation, divorces, etc. So, Drake's pathetic lawsuit against UMG or Megan Thee Stallion's lawsuit against the blogger are both considered civil cases. And now, before you start tossing around lawsuits left and right, there are a lot of things to consider. 1. Civil lawsuits are expensive. Considering the cost of filing the suits, getting the lawyers, or etc., the expenses could range from a couple hundred to thousands of dollars. And if the party that you're suing doesn't even have the money to pay what you're demanding, it's a big loss on your end. 2. Time and effort. A lot of manpower is needed to successfully go through with legislation. So make sure the time and effort you're putting in is worth the reward or compensation that you're getting. Now for the interesting bit, criminal lawsuits. This involves the government taking action to persecute someone who has committed a crime, them being called the defendant. The burden of proof for criminal cases are much higher, the government, or prosecution, having to prove beyond reasonable doubt that the person committed the crime. A way to differentiate between civil and criminal cases is that civil cases are entitled plaintiff versus defendant. Whilst criminal cases are usually titled state versus defendant. In the US, criminal cases are done in criminal court, whilst in countries like the UK, it's a little different. All criminal cases begin in the magistrate's court and are moved up to the Crown Court if the case grows in complexity. Indictable offences, or serious offences, go straight to the Crown Court, such as murder or robbery. From here, it's basically the same process for most jurisdictions or governments. There will be a plea, and if the defendant pleads not guilty, preparations for a trial will commence. During the discovery phase, all evidence must be shared between parties, and motions may be brought up for a party to share or remove certain pieces of evidence for many reasons, such as if they were obtained illegally. Within the next few months or even a few years, a jury of 12 will be selected and the trial will begin. The trial begins with opening statements. The prosecution goes first, and the defense can choose to say it after the prosecution or withhold it until later. Remember, it's the prosecution who has the burden of proof. The opening statements provide an overview of the counsel's arguments by laying out witnesses and what they would say. Afterwards, the prosecution will call up their first witness and do a direct examination, asking questions and accounts to support their argument whilst presenting evidence. After they've asked all the questions, the defense will get a chance to cross-examine the witness to gain more information. Then the prosecution will re-examine the witness if they want to. The questions asked during examinations are direct, and witnesses are often trained in advance to answer truthfully without overdoing it. After this process is done with all the prosecution's witnesses, the same will happen for the defendant. Objection! Did you really think I'd forget one of the most iconic aspects of a legal trial? Objections are made by opposing counsels to ensure an examination is going properly. The judge may choose to sustain or overrule them. Some reasons for objections include hearsay or a statement made out of court, irrelevant questions, asking compound questions or more than one question at a time, and badgering, asking a single question or a similar question many times, expecting a different answer. After the examination come the closing statements, where the parties must try their best to persuade the jury, reminding them of key points and using hypotheticals to advocate. Afterwards, the jury will decide on a verdict, and if found guilty, the judge will sentence. Depending on the crime, these sentences can last from weeks to months, or even life. In many cases, both civil and criminal lawsuits could apply, the criminal suit being to prosecute the defendant and the civil suit to compensate for damages. For example, in an assault case, the criminal suit would be to prosecute the assaulter, while the civil suit would be to pay for any hospital bills or damages that were caused. Well then, Wanderer, it appears you have reached the end of this guide. Obviously, not everything about lawsuits or trials is in here, but I really hope you took away some new knowledge. Thank you for watching, and I hope your future journey is far away from any lawsuits, criminal or civil.